Good evening, everyone, both here and online. Obviously, there'd be more people here tonight if Arsenal hadn't been playing at home. We have an interesting panel, a distinguished panel, with Ingo from the EPO, Florence, President of the Court of First Instance, a surprise other judge by Zoom, or whatever it is, who will be here for 3 minutes on the way. And then we have the people who use the system, Ed and Ansley. I suppose in the end it's going to be how the latter two use the system that will dictate what actually happened. But at the moment we're looking at predictions and questions. What we've done is I prepared a sheet and they've seen the various things, one of which should be the problem. We got the problem there? No, we haven't. Can we have the next slide? We should have had the problem up. Oh, something's gone wrong. Okay. This problem relates to the difference between the way courts read patent specifications and the way the European Patent Office does. It was circulated about a month ago at a conference in the EPO to illustrate the point. Claim 1, composition comprising compound A and a water-soluble protein. So it just says water-soluble protein. Claim 2, composition according to Claim 1, where the water-soluble protein is protein Y. Patent says this: a composition comprising compound A and protein X is known. It has certain drawbacks. We have found that a composition comprising compound A and water-soluble protein instead of protein X performs better. Water-soluble protein, as used herein, refers to proteins which are water-soluble according to test T. Protein X does not fulfill this requirement. Protein Y does. Question: does the prior proposal of compound A and protein X a prior document discloses a composition comprising compound A and protein X. According to a prior art test U, protein X is water-soluble. D4 is therefore, that was the prior art document, novelty destroying. So the patentee had said water-soluble protein means water-soluble according to test T. X does not satisfy that condition, and yet the Patent Office, in a straw poll, about just over 2/3 said it was anticipating. I put this to various judges of the European Court, both in this country, I've sent some by email. They all think that it is not anticipating, that the approach of the Patent Office to claim construction is effectively to look at the claim as a freestanding claim and not pay too much attention to what the patentee says things mean, or what you must interpret them as meaning. What we, the English, call purposive construction. So one thing that's going to come up is a conflict between the court and the EPO about claim construction. We don't have to resolve the details of this case at all. Want to assume that is so. What are we to do about it? Should the EPO follow the judges? Should they continue to do their own thing? My first question is to you, Ingo. Should the EPO follow the judges, or do you think the judges should follow the EPO?
Is it turned on now?
Yeah.
Okay. It depends. It depends, and I think the question, sorry to say that, might be a bit too direct to answer it. Robin, you know the system and the assessment that's done at the EPO as the patent granting organization is different, and it's different for good reasons, because it is different for good reasons because it is designed that the patents that are granted should be clear on their own, and it should be clear to all users and not just to potentially two parties. And it depends, because also in this particular example that you give, it would be nice. We had a small discussion when we prepared for today's event here, whether it could be a solution to put test T into the claim. I would doubt that this would be accepted by the EPO as in the patent granting procedure, because a reference to a test T just as such might raise issues with clarity, because then it might be very difficult for somebody to define what is really meant by it. On the other hand, if test T is something that is well known to the skilled person in the art, then the outcome might be even the same, because then the skilled person, as the one reading the claim and understanding the claim, might come to exactly the same solution. So as always, an example might look very, very difficult, but in the end, when it boils down to find the answer, it depends. Everything depends upon what the skilled person does on this case. So it is not, for me, it's not a question whether the one follows the other. It doesn't matter which one follows the other, but it is in the end it comes to the core issue that the claim needs to be understood by the person skilled in the art, and that's our standard. That's our notional figure that decides whether a claim can be granted and whether a claim can be maintained at the level of the granting procedure.
Well,
you're not happy. You want to have a different answer, but you won't get it from me.
I think that's very likely. Florence, now then, how will the UPC deal with something where the patentee says in his specification that something he later uses in the claim means something specifically?
So, to answer this question, it's not easy first, because I think we will not refer to our national frame, and so it's what I am used is that generally we read the claim with regard to the description, and we ask for the validity and ask for the infringement as well, both. And it's we have a general approach. For example, even in our judgments, it's always read the same way, meaning that there is a first part, which is the scope of the patent, and then we refer, for the whole decision, we refer to the first part, dealing with the scope of the patent with regard to the whole patent, and not only the claim, but the description and
Yes, that's the difference. For what it's worth, I've tried this one on a few UPC judges, and they all seem to agree with the English judges, who think clearly that there is no anticipation. If the patent says, according to test X, in the body of the specification, and that's what he means in the claim, that's what it means in the claim. So we are going to have differences between the court, just as we do now with national courts. Will the EPO pay more attention to the UPC decisions than decisions of national courts?
Here I can give you a clear answer. We pay close attention to judgments stemming from national courts and also from the UPC. Having said this does not mean that we always come to the same conclusion. You might end up before different courts in different countries with different solutions on similar cases. And the same does not mean, if it happens at the EPO, it does not mean that the system as such is wrong. We will have a close exchange also with the UPC. That's already foreseen, as we have this exchange with the national judges, and we learn from each other, and we listen also to what is done by judges in infringement and validity cases in the EPC contracting stage, and this includes also naturally the UPC as such. Again, it does not mean that we have to come always to the same result. To give you one example from my own experience as a previous German judge, we have differences with German approaches before German patent courts and the EPO. However, when it comes to the conclusions, the differences are not that much, and there is, at least I know from only one German case that was decided by the Federal Court of Justice of the Patent Senate, where the court decided to construe a patent claim contrary to the wording, but in line with the description. It was just the other way around, because they said that's in the description, and therefore the description prevails over a different wording. For me, it would be difficult to predict that this would be the same in the future at the EPO. The solution again is to be found by construing the claim that we do as well, but we do it through the eyes of the skilled person. The skilled person knows the description, but the order, the structure of our decision looks different from the structure of a national court decision. But this does not mean that we come to different solutions. And even in an example like this, Robin, I do not take this as a fundamental or structural problem. I take this as an issue that is the case at hand to be decided by different judges, potentially with different outcome.
I'm going to just come back and do one more on that. Will you pay more attention to the UPC judgments than you will to United Kingdom judgments or judgments of the Court of Malta?
We have for the EPO, it is the contracting stage and the court of the contracting stage that we will look at, and the authority that is incorporated in those judgments is about what we take into consideration. The UPC, because it's not just one contracting stage, it's a plurality of contracting stage, will have a particular authority. But please do not ask me, and do not try to get any confirmation that we give double importance to a UPC decision, because this would go against what is written into the EPC. It is the EPC, and the European Patent Organization is an international organization, and we have to pay attention to our contracting stage and to their courts. And the UPC is one player. It's a very important player, but it's one player.
Well fudged, sir.
If I may add something, that I would have said also that we pay a close attention to the decision of the office, because, and also, for example, if we have in files a discussion around the way the patent has been drafted, we have sometimes to discuss the rules that the office follows to draft the patent. For example, to talk about a product including something or composed of something, to assess how does it mean exactly. And so I think the opposite side is also true, but we pay attention to these decisions.
All right, well, that is a sort of opener, the overture. I would now like to turn to how it's going to work in practice. Those who wish to seek revocation for patents for most of Europe, not Switzerland, not United Kingdom, not Spain, not Poland, but most of industrial Europe, have two routes of attack: opposition in the EPO and or a revocation claim in the court. And before the UPC, you could just have lots of revocation claims in different countries. Expensive, complicated, and so on. Now you could have a big knockout for the UPC territory. The question which I want to debate now is, what's going to happen? Are people going to use the EPO system of knockout less than they do now, or have done hitherto? And I'm just going to record something which nobody else ever seems to remember happened. It's because I'm so old. We had an opposition system in the United Kingdom, which included either pre-grant, you could stop the grant of the patent altogether for years, or within 1 year post-grant. The grounds were not quite as wide, clearly obvious, not obvious if there was a difference, for example. And when we changed our law in 1977, we got rid of that idea. There was no pre-grant, and you could attack the patent at any time in the patent office, no longer within 1 year. The patent office thought they would have a lot more work. All patent office opposition, bar trivial amounts, completely stopped. You never hear of such cases anymore. Probably people didn't attack the patent because they didn't have to until it mattered. Most patents don't matter. Will this happen to some extent in the EPO? Now I'm going to ask you, Ed, what's going to be your attitude towards attacking a patent?
I don't think we will see what you observed in 1977. I mean, you mentioned it yourself, but there's a huge difference in geographic scope, and the EPO covers 44, shortly rising to 45 states. The UPC today covers 17, rising to a maximum, if everyone ratifies, that would go up to 24. So there's still half of the EPC cannot be touched by the UPC, and that encompasses some big markets. Obviously the non-EU ones, but Brexit, I think, has done the EPO a huge favour here, because EPO oppositions will remain the only way of centrally knocking out a patent that covers the UK, Switzerland, Spain, Norway, Poland's a big market. So for many valuable patents, I think the EPO opposition will be the only way of getting that geographic scope. I think certainly in the area I work, there are lots of situations as well where what what parties want is some sort of early indication. They can't get onto the market anyway, even if they knocked out the patent, because there are other factors. There's other. I work in pharmaceuticals. There's often regulatory data protection, stopping generics from entering the market for sometimes 10 or more years after patent grant. And in those situations, the behavior we observe from generics companies is they file oppositions early because it's inexpensive. It's 800-900 euros compared with 20,000 for a UPC action, and time's on their side. They can let an opposition play out. 5 years later, they'll get a final decision. If the patent's knocked out, they've still got time to kind of gear up, develop their products, prove bioequivalence, and then hit the market in good time, all relatively inexpensively. They like that certainty that they can afford to wait for. There's no need to stop doing that now and wait and roll the dice at the end. There will be some situations where a quick result is needed, maybe in different sectors or maybe under different facts, in which case the UPC will be attractive. But even then, these aren't mutually exclusive options. I think we'll see parties getting their foot in the door through an EPO opposition for the kind of advantages I've mentioned. And then if they really need it later on, they can launch a UPC action in parallel, perhaps developing arguments that they've worked up in the EPO oppositions. There's also, of course, an established body of EPO case law which often plays in opponents' favour. People moan about the pedantic nature of the EPO's approach to added matter, priority, those sorts of things. And many opponents like that because it's a quick and easy way of knocking out patents. Given that's there, they're going to continue to use that. Why would they forsake that and instead try those arguments before a court that's currently untested? They don't know if the UPC will have the same allegedly pedantic standards as the EPO on those grounds. So I think it will still be attractive for those sorts of reasons. I think that the final point I'd make is sometimes the EPO does an extremely impressive job. But when you consider it costs less than 900 euros to launch an opposition, the EPO, given those resources, does an extremely impressive job in diving very deeply into the technical detail. I did an opposition hearing last year that lasted for 8 days. First instance hearing, 8 days long, immense technical detail. And I've never seen that level of detail replicated in the national courts covered by the UPC. I've done hearings which last for 3 days at the EPO, and then the German proceedings are done in a morning. And often, with respect to German procedure, it goes into much less technical detail and feels less satisfactory than the EPO proceedings. So I think there will still be an appetite. So yeah, I wouldn't worry yet, Ingo.
Florence.
I
Florence,
think
how many? You've got? Do you have any figures of how many attacks on patents have been made in the UPC?
yes, I'm take my place now.
Okay.
I think we are not competitors.
If I refer to my, maybe it's quicker if I go directly to the figures with my notes.
Okay, please give.
No, maybe I can show the slides because it's interesting. So I go directly to the last ones. It's not interesting. Yes, I was just wondering whether it was important for the users, the distribution of the cases. If it
Yes.
had an impact, because it is true that some users were until the very close to the start, they were wondering where they should launch their action. And
I was just wondering if it should have an impact at the beginning, and then in that regard, I don't have the answer because, but I can just say that as following my experience as a national judge, I was surprised by the number of cases launched in the central divisions with the revocation action, direct revocation. So at the moment we have 22 revocation actions, so 18 in Paris and 4 in the Munich section. And we have in parallel, because I think to think about the whole picture, we have to consider also that at the UPC you have the two routes. You have the revocation, the direct revocation action, and the counterclaim for revocation in case of infringement action. And as a national judge, I had very rarely cases, direct revocation cases. So I was surprised by this result. You can hear me, I think it's
We're just gonna pop this one in. It's just not picking up online. So
I'm not sure it's necessary.
just speaking.
Thank you. And as for the counterclaim for revocation, I think it's you should not pay much attention about this number, because actually at the moment, as you may know, the functioning of the UPC, you have a main case and you have the related proceedings, and then for example 42 counterclaim for revocation, it can be that, for example, in an infringement action with a number of defendants, they all make a counterclaim for revocation. So it increased the number of revocation counterclaim for revocation for one against one patent. So this number is not. It's interesting, but it does not reflect the reality.
I was at a conference last week where some American attorney said that he had just filed 9 revocation actions in the UPC.
Yes.
That may not have reached your figures yet. You said there were 23 in Central Division?
All the actions are here. And which is interesting, I think it's to compare, and then you have here the whole picture about all the actions launched so far before the UPC, and the proportion of action are interesting. I think the revocation it's still a significant number, and the most interesting one, I think, is this one, because so far you can see that it is exactly the same proportion with and without opposition pending. I don't know if the UPO has the more accurate statistics, because we are counting at the moment. We don't have that in the case management system, so we count that manually. And this is the first picture we have. But this opposition can have been launched earlier, for example, in 2022. But I don't know if you have more accurate statistic. I don't have more.
If there are parallel actions in your court and opposition proceedings in the EPO, will your court wait for the EPO, or should the EPO wait for your court, or they just proceed separately?
This question is interesting. But when I prepared the conference, I discussed with one of my former presidents at the Paris court. And I explained that I said I'm going to London and I will be attending conference and about the parallel proceedings with the UPO and the UPC. And her spontaneous reaction was, "This topic is not new. It's not new." But I think it's not new. It's not completely new, but it's new because we are in a different frame and because of these time limits. And as a national judge, I would say that first, no, I don't, I mustn't talk about national, what would do a national judge, but in the UPC, I think I would first refer to the rules, because in the rules you have to take into account the interest of both parties. It's one of the most important requirements for all the decisions to be taken, and then waiting that, and I think in a lot of cases I think the interest of the parties is to have quick decisions. So I think I would be inclined to continue the proceedings, but I think which will be very important in the system is the information, the exchange of information between the UPC and the UPO, because of course, which is very important for us, will be within which time limit we may consider that we will have a decision. And so there was so far there was just one request for stay, because I think sorry if I am not very organized in what I am saying, because it's not my native language, and we have to consider two aspects. The first one is if will the judge spontaneously ask for an acceleration of the proceedings? Is the first question, and the other question is to which extent the judge will take into account the proceeding in course at the UPO. I think it's two different questions. And in the UPC, as the judge rapporteur has a more important role, is more active if we compare with the judge in the national court, it can take more initiative. It's a different. It's to some extent a different role, and then we could consider that the judge may more easily or more spontaneously ask for an acceleration on his own motion. But I'm not sure if it's really the role of the judge to do that. I think it's more for the parties to take the initiative to ask for an acceleration. Yes. It's a personal view, and it's more my practice. But to answer the question, I would really reserve the stay for very particular situation. And I think the users expect from the UPC to be quick. I think it's something important for. It's the reason why. One of the reasons why they will use the court. So I think it would not make much sense to postpone a lot the course of the proceedings. But at the same time, I think it's also important that, because I was talking previously about the interest of the party, I think the interest of the parties is also to have to avoid conflicting decision. I think it's also important for the legal frame and the fair competition. I think it's also something important. So I would say that we should find solution to have quick proceedings, because it's an expectation from the users. But we also should, as much as possible, find a way to avoid these problems of conflicting decisions. It would be my conclusion. I don't know if I understand really.
No, you understand. The actual rule, I've just been reminded, says the court may stay proceedings where it is seized of an action relating to a patent, which is also the subject of opposition proceedings for the EPO or a national authority, where a decision in such proceedings may be expected to be given rapidly.
Yes, and then about that, which is interesting, is that we have to define this concept. What is a rapid decision for?
How rapid is rapid?
what is a rapid decision and what is a decision as well, because it is a definitive decision, it is a relevant decision for the case. What is a definitive decision? What is a decision? Shall it be a definitive decision or a decision, and depending on the situation and the circumstances. And I think the role of the judge in this case is to assess the most probable scenario, what will happen before the UPO, and if the decision will be appealed or not. So I think it's really on a case by case basis, but basically to make sure that we maintain the main requirement for the UPC to have proceedings handled within 1 year, which is the requirement, and at least close to this requirement. So,
Ingo, the office has just was about to issue a document indicating that when there are parallel proceedings, they're going to speed oppositions up. How long would it take for a case, supposing the patent is granted and an opposition is started 9 months later, and then the revocation action is launched at the same time? How long would it take the office to get through under the new proposed rules, knowing of the existing parallel proceedings?
Robin, I sense that you want to have a figure, and that you and that you want to have a figure that is below 12 months to mirror what Florence said. Let me first just say something to clear up that I think there is no distinction between what you, Florence, said about the interest of the users to have a speedy decision, the attempts to avoid any conflicting decisions as much as possible. There might be conflicting decisions because the submissions from the parties are different. Therefore, the subject matter that is decided or the case might be different before a UPC panel or the EPO. But overall, I would subscribe everything that you said. Now I come to the timing. If I take your case, then it would be your particular case. Then it would be too long, because your case was that the proceedings before the UPC started at day 1 of the opposition period, and then it would take, in that case, it would take 9 months before the opposition division could start, because the opposition division needs to wait for the expiry of the 9 months before it can start, and then it might, and this is the notice that will be issued next week. Then it will start for the opposition division to accelerate the case. Cannot accelerate the opposition period. It can only accelerate after that. But then it would take another 9 months max to issue the decision of the administrative division. Then it is for the UPC to define whether this is a decision within the meaning of Article 198 of the Rules of Procedure. But let's go on for the entire proceeding. Then it would end up with potentially with an appeal. The appeal period cannot be reduced because it is a statutory period. But once a board can start, it would take between 6 and 9 months to take a decision. So if I count everything now together, 9 months for the opposition period plus 9 months makes 18 months plus, let's say, 6 months or 9 months, doesn't matter, it's too long. I'm not arguing this. But this is for me, this is just one scenario. There are many other scenarios.
Yes.
One scenario is that the parallel proceedings start at a later stage. They start after the expiry of the opposition division. They start after the summons to oral proceedings before the opposition division. They start only at the appeal level. And if I take that, then that they start at the appeal level, then we have prepared everything at the boards of appeal to issue a decision within 6 to 9 months. And whether this is speedy enough for the UPC, it's not for me to decide, it's for the UPC judges to decide. But we have to take into account, and we cannot go back to or go below the statutory time frames that are set in the EPC. That's the limit that we have. When it comes how is this acceleration triggered? And you talked about that. It can be triggered by a request of the UPC, for example, like with all other national courts, that they request acceleration either with the opposition division or with the boards of appeal, or it is the parties that can do it. But the new system that is now in place with the office, or will be in place with the office, is long in place with the boards of appeal, is it's acceleration ex officio, what we call ex officio. That once we learn, that once we become aware of parallel proceedings, it would be then for the opposition division and or for the board to accelerate at its own motion. Not to wait for a request by a party, for a request by a national court. And this is not only true for the UPC, and now I'll come back to your first question. For us, the UPC is a very important court, but we still have the national courts as well. It doesn't matter whether there are parallel proceedings before an English court or before the UPC. If you become aware of the one or the other, then we have this ex officio. We will have this ex officio acceleration either at the opposition level or at the boards of appeal level. But now let me come back to the conflicting avoidance of conflicting decisions. This is, for me at least, of utmost importance. This is true for national courts, but it's even more true for the UPC because of the scope of application of your judgments. It might be acceptable to have conflicting decisions between national courts in different countries. This might happen. It might also be acceptable to have conflicting decisions between the EPO on the one hand and the national court. But when it comes to the UPC, with that many countries being covered, that would be something that should, I may even say, that must be avoided as far as possible, unless it is really justified by the particular circumstances of a case. It might well be that an opponent is better before the UPC than she is before the EPO, and the UPC can, or a national court, has a better case or a more complete case than the EPO, or vice versa.
Yes. The rule talks about given rapidly, but let me ask this. What about other considerations? I mean, if the chap says, well, why do you want this in a hurry? And the court asks that question. Why do you want us to deal with this as soon as possible? In an English court, you'd give your commercial reasons as to why you wanted to do it, because you had plans to do something and so on and so forth. Not just to be quick for the sake of being quick. Will the court take into account the commercial considerations of both sides? And the EPO for that matter? Florence?
I would say yes, because it's part of the assessment of the interest of the parties. So, but if I understand well what you said, Ingo, it means that there is no reason now to ask for accelerated proceedings because it's done automatically by the
Yes, that's the idea. We have this interface between the UPC on the one hand and the EPO on the other hand, that we get automatically the information once a European patent is before you. And this is then transferred either to the opposition divisions or to the boards of appeal, and this then triggers automatically because of this notice that will be published next week by a notice of the president, or will be triggered by us on the basis of Article 10.6 of our rules of procedure. Those rules of procedure are in place since 2020. We already have this system. but for the time being, there were no automatic awareness, if there was a case before an English court, that we didn't know about that unless the parties told us.
Yes, you have to be told, I think, under this new rule, if it is informed by the UPC.
But we are informed by the UPC.
You are.
We are informed by the UPC due to
No,
this interface.
it's a very important aspect of the rule, I think, because this information is systematically provided. It's-
Right. So you'll know about every one of them.
Yes.
Yes.
But the rule says if it is informed by the Unified Patent Court. But we now know there's going to be an automatic system for informing.
It is. It's an automatic system.
Right.
of
From
informing.
both sides.
From
From
both
both
sides.
Is it the
sides.
same system as the filing system? That's about issues.
It works. I can assure you, it works quite well because we do have a number of cases that are known before the opposition divisions, and we have 3 cases before the boards of appeal, and those have led to acceleration by immediately summoning the parties to oral proceedings. And like now I explain something to you. Having been a national judge before, Robin, you know that I did. I would have issued the same decision line of reasoning that you did many years ago, that it not worth waiting for the EPO to decide. But this has changed. But this has really changed because I can, before the coming into force, the entry into action of the UPC, in my former capacity as a chair of a technical board of appeal, I received even phone calls by chairs of national courts informing me of their parallel proceedings, and they asked me, what are your next procedural steps? Can you speed up? Can you inform me once you have the oral proceedings? Could it be a bit earlier so that we might wait? It was then still the decision for the national judge, for the UPC judge, to decide whether to stay. It's not for me to decide, but at least there are options for informal contacts to let both sides know what the other expects or can do.
It's not like that you said, and just me. I've been reminded that what I said was that waiting for the EPO was like waiting for Godot. And that's no longer true.
That's no longer true.
That's what it boils down to. I wonder whether you might consider changing your rules. English rules for appeals, for example, say what the time is, but the court has power to shorten that time. You don't have that power.
No, we do have it. Sorry to say, it depends. There are time frames set in the EPC.
Yes.
And we cannot disregard those.
They're in the EPC itself.
They are in the EPC, like the period for filing oppositions, the period for summoning to oral proceedings. It's 2-month minimum. However, for the last one, it is possible to ask for the agreement for the consent of the parties, and then we may deviate from those. But this is only possible with their exceptions. With what I told you about the 6 to 9 months before the boards of appeal would mean the maximum reduction of all possible time limits. This would bring us down to 6 months, and below that would be. There's a quality issue as well because it needs to be prepared by the board, by the rapporteur. But this would mean that the time limits for the parties will be set at a minimum, and not all parties are very happy with only being confronted with minimum time frames because they would like to prepare as well, particularly in pharmaceutical cases or biotech cases. If you tell somebody you have 2 months to prepare tests, then your client might tell you, what do you mean by 2 months? I might set up the first test for it, but I won't get any results for it. So it really depends, and you cannot, if you want to have quality decisions at the end, you cannot always go to the minimum. There might be other cases in the field of mechanics that I know better than pharmaceuticals, where you can go to the absolute minimum because everybody could live with it, but it's case related.
In some situations it's not avoidable the time, but more generally I would say another thing that surprised me in the UPC frame was that finally the parties comply with the time limits. And then I think if the frame is quite strict, it works. And I was also surprised by the result, because before the start, I thought that it's really challenging and difficult for the representatives. And then so far, I'm not informed that there are so many important requests for extending the time limits.
In France, it is like this with lawyers. They always do things at the last minute. So the only question is, when is the last minute?
Yeah, but at least, Robin, but at least now we have an option in there will be an amendment to the rules of procedure potentially coming, or hopefully coming into force 1st of January. This will allow to summoning to oral proceedings already at the beginning of the appeal procedures. And this is the idea was in particular in view of potentially parallel proceedings, because this would then trigger make it obvious to everybody concerned that everybody needs to speed up to be ready by the date of our proceedings. This was not possible under the old system, but it will become possible.
So this is fix the trial date, and everything fits around that.
Mm.
There is a Dr. Johnson, who you may have heard of, wrote the first English dictionary. He once said, "There is nothing like a hanging for concentrating a man's mind wonderfully." And this is extremely good news for Europe. Europe patent system is going to be working better, faster, give you results or settlements. I'm very encouraged. Do you feel encouraged looking at it from the point of view of a part American? You are an American, but looking at it from the point of view of an American firm, that this may be moving the center of litigation to Europe?
Well, as a partner at an American firm based in London, I'm very encouraged by it. And I mean, that we've always known that the UPC was going to give U.S. litigation a run for their money in terms of, once everyone ratifies, the scope of the consumer market is much bigger than that of the U.S. So there was always going to be a pool there. We're still in the early days. There's still parties that are looking to see what the outcome of various decisions are going to be before they take that step. But I think the big question, I think, as a litigator really is what happens when there are conflicting decisions. And in particular, from my perspective, a few years ago, I did a study of 25 countries as to what they do when there is these parallel proceedings. And so we have concurrent jurisdiction with the EPO and the UPC and national courts. And the question is, which I'm happy to go into now, or I don't know what your running order is.
Perhaps we just ought to have, we have a surprise extra. Another judge of the UPC is going to join us by whatever it is, Zoom or Teams or something. He has dealt with an application for a stay, as I understand it, pending in the pending decision in the EPO. And this is Judge Kopek. Good evening. Thank you very much for coming.
Well, thank you. Thank you very much for having me.
Welcome to UCL.
As a surprise judge, I'm very, very honored. So, and indeed, I have been listening, fascinating to everything that has been said by all your esteemed speakers. And indeed, in the Munich section of the Central Division, we had to deal with this, to the best of my knowledge, first request to stay proceedings, and we had to apply Article 33, paragraph 10, that was already cited, which speaks about a decision which is expected rapidly, neither of both being defined indeed in the agreement or in the rules. So just to summarize our conclusions as a panel, is we arrived at the conclusion that a decision, I think also as mentioned by Florence, does not have to be a final decision from the EPO, it can be any decision. And this rapid suggests that there should be a concrete expectation that there will be a decision in the near future, and that this decision is going to be rendered before the UPC decision. So in that case, in the case that a rapid decision is indeed expected, there is discretion. Now, we assumed in our case where the claimant indeed had established, in the panel's view, an interest in having a speedy decision, and the defendant patentee opposed basically on the grounds of, or asked for the stay basically on the grounds of saving litigation costs and efficiency. We assumed that there was a rapid decision because in our case, our hearing was scheduled for the 24th of June, top of my mind, and the EPO hearing beginning of March of next year. So we said in the panel said in the order that it was doubtful whether waiting for 4 months for a decision was actually rapid, but we assumed it nevertheless in favor of the claimant, and then we went on to weigh the interests of parties and decided not to stay the proceedings because the interests of the claimant in getting clarity in view of its position vis-a-vis the patent outweighed the interests of the defendant patentee to save litigation costs. But we also said, panel said that, and recognized, which also was echoed in what I just heard from the previous speakers, that conflicting decisions are undesirable and are to be avoided to the largest possible extent. And therefore, we rejected the stay at this point in time, but we also said in the order that should the EPO revoke the patent at the opposition hearing in March, then we would be inclined to at least wait until the outcome of the EPO proceedings was final, because if it is not appealed, then there is no more patent. And we also said, and again, in the interest of avoiding conflicting decisions, we wanted to at least have at our disposal of the panel the grounds of the opposition division, so we could look at the grounds. So we said, and that was a non-binding view given in the order, that we were inclined to at least wait until that would be available. And we also said, actually anticipating the notice we just heard about, that we would contact the opposition division to ask them to make sure that the written grounds were available before we had our hearing, which is still 3 months later than that. So, and that is an order just very recently given, and we thought it would be nice to give a summary of that because it was so topical, and it will be published on the UPC website.
Thank you very much indeed, and thanks for coming. Anybody want to ask him any questions? Because now's got to be the moment.
If 4 months isn't rapid, what is rapid?
Well, I mean, that is a good question. I think the only thing we said about it is that we were unsure if that was rapid. So and indeed, it has to be a fixed date, and it has to be significantly before a UPC decision. So we felt that we did not have to conclusively, at least that is how it's set in the order, we did not have to conclusively answer that question. So that will be for the next panel.
Okay.
I think rapid, it depends completely on the case. Because if it's convenient, it's rapid. We can conclude that it's rapid. If the time limit, yes, is suitable for both sides, it's you can consider that it's
rapid it's to be assessed. I think it's we cannot say there is no definition of rapid decision. The decision has to be taken at one point of time, which is convenient for both.
And if I may add to that, the outcome of the opposition will be announced at the end of the oral proceedings of the opposition division. Therefore, at least the order will be already public at that point in time. And with the new system of ex officio acceleration, I think the opposition division would be more or less invited to issue the fully reasoned decision rather sooner than later, and not to wait for 4 months, but to immediately start working on the written decision, on the fully reasoned decision that would then allow you to analyze it and to see whether it has any bearing on the case before you.
But it is always possible for the UPO to know exactly within which time the written grounds will be.
I think for the opposition division there is no clear time frame. We have a clear time frame for the boards of appeal. But anyway, if it's accelerated, then the deciding body is asked to give absolute priority to the case. And priority means that there is not a full use of any time, and we have up to 3 months at the board's level, but not to use then the 3 months at the board's level, but to work immediately after the end of the oral proceedings on the reasons. And then it can be, because we know this from previous experiences, it can be a matter of a couple of weeks to have a written decision out. Out means notified to the parties.
It sounds extremely promising.
But I do not promise them.
And by the way, in our case, and I think you made a very interesting point. Indeed, the opposition, the result of the opposition will be known at the hearing, and as this is also in the order, as our case at the UPC plays out, and this is how it nicely shows how these cases work together. We have an interim hearing planned just after the 10 days after the opposition hearing, and then the court will be informed by the parties on the outcome, and we can take it from there.
Brilliant. Any more questions? No. You can stay. It's nice seeing you up there. I've gathered you've been listening already, have you?
I have been with a lot of interest, but I will go on mute now and also put my camera on mute so you can put your slides back on.
All right. Thank you very much.
Thank you for having me.
Right, where are we now? What time do we finish, Lisa?
No, my only question is whether it's necessary that I stand like this since some time, and I'm not sure if it's necessary actually.
What time do we finish, Lisa?
7:30, but we can, if you're having.
We can press on. Okay, very good. Normally people have had enough by 7:30, especially when they know there's drinks outside. The court has got a lot of work on. Florence, the court has got quite a lot of cases. Are the judges happy with the number of cases they've got, or are they worried they've got too many?
They are happy with the number of cases. They expect that, and we are working on it, but the court will be able to adapt the working capacity accordingly. Because, of course, the question was at the beginning we had absolutely no idea, and then and also the frame is completely new, so which of course is important is that from the point of time where it will be necessary to
have more judges in the different divisions, it will be easily possible.
That's all very satisfactory. Not too much, not too little.
Because of the working time, because most of the judges at the moment are part-time, and then can be by decision of the presidium can be increased. So it's a decision of the presidium, but of course depending on the. It's a difficult exercise because I remember that in the national court, at least in France, and I think it's the same everywhere, it's very difficult to assess the working time of a judge. Then it's only with the time that we are able to do that. Also because we are in a different frame, and as we can hear with the way I express myself, it's not the same because we speak another language. We draft decisions in another language to some extent, and so which takes more time. But we have started to develop ways to assess the workload and to adapt the court.
Can I ask the practitioners, will the English patent court become less important?
Absolutely not. There's only one answer to that question, Robin. I think it's actually become more important. Our courts have always been very commercial and responsive to what's going on with parties and what's going on within other courts. And I think they will be as reactive and nimble as always. We are seeing a lot of expedition happen in the last several months as well. Again, looking at wider impacts of parallel proceedings, and that is just going to continue afoot. There's going to always be pressure on our costs. That's the favorite, refrain from German litigators is that we are very expensive. I don't believe or buy that for a second when you look at kind of the global litigation costs. Our judges are highly respected, and as Ingo says, the EPO is not just looking at the UPC, they're looking at national courts in the EPC states, and that includes the UK. So it's business as normal.
Ed?
That all chimes with me. I've got little to add to that. I think for the very small fraction of cases that do justify the cost of English litigation, I think they'll continue to do so for the reasons you've just articulated.
Well, there you are. The two patent judges are sitting here. They thought they could go off and do something else.
I think it's a choice from the representative because it's a different frame and it's something new, especially regarding the technically qualified judges. It's and I am wondering also. We discussed before if there will be more converging positions, and most of the technically qualified judges are very familiar with the proceedings before the office, for example.
Yes, because they're nearly all patent attorneys.
A number of them, yes, and
Most
it's a different, but it's a different and complementary
Have you-
compared to the judges.
Have you sat with a technically qualified judge yet yourself?
No, myself no. But, currently I don't have judicial activities. It's simply impossible with my role. Apart from the decision taken on language change request, and
Oh, have there been many cases with requests for changes of language?
so far, yeah. No, I'm not sure if we can consider that it's much, but 7 requests and 1 change, as far as I know, 1 change by agreement of both parties to come into English from German language.
Right, let's have a few questions from the audience.
This is perhaps a late question.
Hang on, get a mic.
possibly I'm asking this late. It relates to the rationale for automatically accelerating opposition proceedings when there's proceedings in the UPC. I understand that if the Technical Board of Appeal revokes the patent, then there's no need for the UPC to go on and consider the validity of that patent.
Is that mic working? I'm not sure it is. Can you hear?
The light's on. Sorry, I'll speak up. Sorry, Robin. My question relates to the rationale for accelerating opposition proceedings when there's parallel proceedings in the UPC. One observation is, of course, that if you automatically accelerate the proceedings when no one's asked, you also bump back possibly the opposition that other parties are involved in, and the interests of those other parties might be adversely affected. But regarding the rationale, I understand that if the Technical Board of Appeal revokes the patent, then arguably there's no subject matter for the UPC to consider. However, what considerations might play when there's a divisional that's recently been granted with the same or nearly the same claims, where that could be the subject of further proceedings. And I think people in this room know much better than me a scenario which the English courts have faced in litigation involving URIM.
Yeah.
Apart from the fact that you're right with if there's a revocation at the final revocation at the EPO level, then that's it for all contracting stage, and this will cover also the UPC area. But there are alternatives to that. The patent might be maintained in an amended form, and this could then become relevant before the UPC as well for the parties to the UPC to consider whether they have to adapt their strategies. They might be well advised to do so, but it is there are many different scenarios that one could expect. For the second part of your question, parent and divisionals, at least when it comes to the boards of appeal, those cases appear more or less at the same time. There might be a couple of months difference, but they will be treated together. And they will be what we call consolidated. So they will be treated at the same date of oral proceedings, and the date of oral proceedings might well be, as Edward said, maybe several days of oral proceedings, but will be dealt with more or less together to have one decision, two decisions, but to have the same line out to inform the public of the fate of the divisional and of the parent.
Any other questions? Comments? Yes. As you could say your name.
Thank you. It's Laura Ramsey. On the topic of avoiding conflicting decisions, it seems to me we've missed a sort of novel situation that we're in. I mean, previously, we know that national judges were very comfortable reaching their own decisions regardless of what was happening at the EPO. But now we have a situation where we have many technical judges who are EPAs. Surely they're going to feel a lot less comfortable coming to a conflicting decision to the EPO when that's the law that they're used to applying. So do we think that this is going to then change what happens?
Wow.
Another difference is that we are, as a national judge, we were not all used to amend, to take decision regarding the scope of the patent, to amend the patent. But, for example, I talk about what the case in France, that we can consider a claim not valid, and then go to the second claim, and then to say a claim valid or not valid, but we could not amend the patent. And then they at the UPO, at the UPC, sorry, we are going to receive a request for amending the patent, so it's also something different. It's a different frame.
That's not so different for the English. We could amend the patent in court.
Sorry?
We had a procedure for amending the patent by the court. And it was very similar. I mean, I think it's the English procedure helped design your rules. You can't, they're not...
Including the dissenting opinion.
including dissenting opinion. Yes, you have that too. The amendment things, you've got to be very careful that the patentee doesn't mess you about and turn up the day before the hearing with wholly new claims which nobody's dealt with at all. So you have to do it in advance, and it's not too many, and it's in the rules, and you've controlled that.
And the number of auxiliary requests.
Yes, yes.
It's the same for the UPO or not?
Yes, it's very similar procedure.
If I may answer to that question of avoidance of conflicting decisions, I'm not very sure whether there is really a game changer that we experience now, because at least it was practice in the past as well for the boards of appeal and also from national courts that I know better, particularly in Germany, that we took into account as far as we knew. It was as far as we knew that was the whole where the cases needed to go through. But at least at the boards of appeal, we do have a systematic approach of being informed of decisions from England. We have our legal research service that circulates all those decisions, so we follow what happens there. In Germany, at least the major decisions are published in certain journals that we know of as well, and in many cases the parties inform as well. And on the other hand, having been a former national judge, we took into account the decisions as well, and you find, for example, for the German Federal Court of Justice, you find citations from the EPO case law as well, as far as it's relevant for the case. Not every case you need to cite authorities of the other jurisdiction, but it might play a role. And at the enlarged court, we do it consistently. We consistently, in the so-called referral case, we consistently look at not all contracting states, because not all have a lot of patent cases, but at least those contracting states with a considerable case law is taken into account. Yes.
Hang on, get the mic. You got
just an observation. It seems inevitable that there'll be conflicting decisions, at least between the UK courts and the EPO, where plausibility arises as a... I'm
aware of that. Even personally.
And it seems to arise often.
It is. I'm not sure whether it arises very often, because if you look at other decisions from the Netherlands, for example, where the what we call the G decision was followed, but it might well be there might be circumstances in a particular case which leads a national judge, to come to a different decision, and that's fine. That's what we have to accept. As natural element of the judiciary.
Hi, James Horgan, Merck Sharp and Dome. At the moment, the European Union is looking at introducing some legislation to produce unitary supplementary protection certificates, along anticipated parallel to the creation of unitary patents, and only like about 10 years too late. But part of the provisions from the Commission on that include the possibility of a post-grant invalidation action against unitary supplementary protection certificates. Do you see any conflict between that concept and Article 32 of the Unified Patent Court Agreement, which gives exclusive jurisdiction to the Unified Patent Court for revocation actions, invalidation actions against SPCs?
This is not quite on the agenda, but...
It's a conflict of laws question, but if you want to pass on from it, that's fine. But it's an interesting topic.
Since the validity of an SPC depends on the validity of the underlying patent, the European Union seems to be proposing to get questions of SPCs considered as European Union law, and therefore, somehow or other, the Court of Justice might end up ruling on validity of patents. Speaking for myself, and perhaps for the UPC, which I had a hand in, I think it's a slap in the face to the UPC. A unitary patent should have a unitary SPC dealt with by the Unitary Patent Court. Yes.
Just a comment, really, agreeing with Ansley. It might sound heretical, but maybe a popular view in front of this audience, that if you really want the right answer, going to the UK will still be a good idea for many cases, I think. I can think of a number of cases in my career where the EPO just will not be able to knock it out, and not really having a go at the EPO. A good example would be a method of making an antibody whereby you throw in a bit of citrate here and then you change the temperature there. The poor old EPO can't really knock that out unless it's got prior art that says add citrate here, change the temperature there. Whereas the UK can have expert evidence, and I hope the UPC will take expert evidence that will make what sounds like a very, very obvious invention. It will say that that looks an inventive step. So the EPO is allowed expert evidence, and you can have someone saying this, and then you just get piles and piles of expert reports that say, disagree with each other, and the EPO opposition division or technical board of appeal just has to make up its own mind. And I think for those cases, and they do exist, the UK will remain a very popular forum.
I do have a comment about plausibility. It's gone wrong here. It's as simple as that. And the Supreme Court refused leave to appeal in that recent case, saying there's no point of law. And it's a pity David Kitchen wasn't there. There we are. I think we should go for drinks. Do you think so?
Can I say something?
Yeah, you can. All right, all right. If you want to say something, please do. But remember, you're holding them up from drinks.
Well, first of all, thank you for inviting me. For those that don't know, I'm a UCL alum. I was actually the first year of students under Sir Hugh Laddie when IBIL was first created, some 15, 16 years ago. So it's great to be back. I'm not going to hold you up from drinks because now Robin's put me in this horrible position. However, I did do some research a few years ago where I did survey 25 countries about what they do when they have these kind of dual track concurrent jurisdiction issues. Because we've been talking about conflicting decisions, but we all know what can happen, and we know from UK experience and Unilin and Zodiac and Vodafone and Neurum and all the others, what happens where you have a national court say that a patent is valid infringed, injunction granted, damages paid, and then down the track, and in Neurum it was a few weeks, but sometimes it's a few months, that patent is held to be invalid. That issue is going to be faced by the UPC. As you said earlier, Florence, it's an issue we have known about for decades and decades. And the question is, what do you do about it? And from the surveys, and I'm very happy to send you my wonderful speech, which I will not be giving tonight to you, as to the status coming from the global perspective, but over 50% of countries face this. But from their experience, there's some ideas for UPC judges as to what to do. And the big question is, when is a decision final? Is it final, or is it subject to be opened and, meddled around with following an EPO decision? So the first solution is obviously speed up EPO oppositions, including to the Technical Board of Appeal. The second one is to look at what a UPC order is. Is it a final order that cannot be revisited, subject to the EPO? Or is there wording in it to allow, for example, somebody to come back later once a patent has been held to be invalid by the EPO TBA, and, for example, have enforcement conditional upon a patentee's undertaking. Patentees will hate that, I understand, but it does try to right the wrong. Another completely probably insane idea at this point, but something to think about as well, is to look at Article 99(2) of the EPC, which extends the jurisdiction of EPO oppositions to the UPC. If a claim is started in the UPC, it might be an idea to actually get rid of that territorial scope and just have the UPC decide it. I can't take full credit for that. That was also an Alan Johnson idea. And the other thing to think about is just using the UPC. And a few years ago, I asked you this question, Robin, as to what you should do about this situation. And you said, forget EPO oppositions, just use a UPC. So 2016 Fordham, Robin, do you still agree with that now today in 2023?
I think with some nuance, yes. I suspect that some people, and nobody else seems to be predicting it, will say, right, the only thing that matters, if I knock it out in the UPC, all right, there'll be a patent in Switzerland and so on. But if there's a big, strong judgment from the UPC saying this patent's no good, that will lead the commercial people to give up. I mean, no patent is ever litigated in every country in the world. You always have a few fights in a few places, and then the thing goes away, it settles. Sometimes people chose the jurisdiction of choice. So I was in two cases, mighty important cases. One was Chiron, which got a Nobel Prize, and they sued in the UK because it was the fastest patent office. And they got judgment within a year, judgment at the Court of Appeal within 2 years. They were still fiddling around with it in the EPO. And the other one was a knockout patent. I was the patentee then. The other one was a knockout. Some stuff called TPA, tissue plasminogen activator. And they wanted to knock the patent out. They came to the UK first because they were getting the first to issue. Revocation claim, day of issue of patent. Judgment within a year, judgment the Court of Appeal within another year. And that really, there was some power litigation in the United States, and then it all died. You've got to remember that no case has ever been litigated in many countries beyond about 6. AP Lady was, I think, the record. And that died when the American patent was issued because they had a clear doctrine of equivalence. End of case. And they settled. And it does show you also something else, how peculiar it is. Really important product, was it? It was complete rubbish. You can't buy one. I've been trying to buy one for my students.
Good clarification. On that note, should we have drinks?
Yes, I think we should. Thank you, panel.